Welcome back to Good Law, Bad Law. You may know her as Notorious R.B.G, but she goes by the name Ruth Bader Ginsburg. And my guest on today's program is Scott Dodson, a professor at the University of California, Hastings College of Law, and the editor of a collection of really, really terrific essays on the life and legacy of Justice Ginsburg, going all the way back to her law school days, her academic career, her years as an advocate for women's rights in the court, playing out the battles in the courts of our country all the way to the Supreme Court until finally in 1993 she becomes only the second woman to ascend to our highest court, the Supreme Court. A fascinating conversation on Justice Ginsburg's legacy, her accomplishments, her role in really shaping the law and therefore so many aspects of our life for women and for men, actually. A really, really incredibly important part of her philosophy about how to tackle gender discrimination and the legacy of gender discrimination in our country. So great conversation about Notorious RBG. Stay tuned. When Ruth Bader Ginsburg has a cold, millions of us hold our breath. And today we're going to talk about why that is. The legacy, the accomplishments of most certainly one of the most influential lawyers, law professors, judges, and Supreme Court justices of the last 50 years. With my guest, Scott Dodson. Scott is a professor of law at the University of California, Hastings in San Francisco, where I was this week for Thanksgiving, and has written a book of essays, the book entitled The Legacy of Ruth Bader Ginsburg, exploring all the aspects of her long and storied career. So first of all, Scott, welcome to Good Law, Bad Law. Thank you so much for being on the program.
It's a delight to be here, Aaron.
I've worked through a good part of the book, and as I was saying to you before we got started, I certainly, as a lawyer and as a student of history and as somebody very interested in issues of equal protection, the Constitution, and the Supreme Court throughout my career as a journalist and as a lawyer, I certainly have been well aware of Ruth Bader Ginsburg and her prominence as a scholar, an advocate, and a justice for now many decades. But it was such a pleasure reading the essays, all written by different lawyers and law professors on different aspects of her career, because there's so much I didn't know. There's so much I don't think I fully appreciated. So the book is really fantastic. And as I also said to you before we got started, it's although some of the areas of law, procedure in particular, may be somewhat technical, most of these essays are so readable for lawyer and non-lawyer alike. And so I highly recommend it, and we'll certainly put a link to where people can obtain a copy of the book in the description for the episode. But perhaps we could start, if you wouldn't mind, telling us a little bit about yourself and how you came to take on this incredible project.
Sure. I've been a law professor for some time, and I teach civil procedure and federal courts, a lot of the classes that most law students sort of roll their eyes and groan at. And so I'm not the most natural person to do a book on Justice Ginsburg. I don't know her. I'm not a court insider. I don't have a background in women's rights or equal protection, which are the areas for which she's largely known. I'm basically a Civ Pro geek who finds interesting all the stuff that most lawyers and legal scholars find pretty boring. But, as it turns out, Ginsburg is kind of a Civ Pro geek, too. She taught the subject when she was a law professor, and I think she appreciates the technical and careful approach that procedure demands. And in fact, she's even said that she would write all of the court's opinions on civil procedure if only her colleagues would let her. She writes many of them, of course, and as a result, my own teaching and writing crosses her opinions time and time again. So I felt sort of a kindred spirit from afar, and I knew of her greater legacy and impact in other areas, of course, but I just thought there was a more holistic story to be told about someone who spent an amazing 60-plus years in the law, and I was also willing to take on the role of spearheading the project, so I reached out to some of her former clerks and received very positive reactions to it, and I also wrote to Justice Ginsburg with a heads up, and she was very gracious, and that's basically how it came to be.
Well, and it is remarkable. She is remarkable to have entered the law when she did. In itself, so many firsts that she paved the way, and the ways in which she's paved the way for so many others. The way when she becomes an advocate in the area of equal protection and women's rights and gender discrimination especially, she paves the way through her arguments, through her writings, for future groundbreaking Supreme Court decisions. And even in the time that, as someone considered to be on the liberal part of the liberal bloc on the Supreme Court, her dissenting opinions, when she's on the losing side, still are seen as being so influential to the ways in which the law eventually will develop. She was, as pointed out in the initial couple of essays, including one by NPR Supreme Court reporter Nina Totenberg, who I knew during my journalism days in Washington. She was a person of so many firsts. Can you give us just some background on her herself and how she maybe sort of take us up to the time when she gets to Columbia, because that's also when she founds the Women's Rights Project with the ACLU and really launches herself into the world of advocacy on issues involving gender discrimination?
Sure, absolutely. And Aaron, I think you're exactly right to start with even her early years, because as she herself has said, she has always wanted to be the kind of person who is willing to listen and throughout her days to learn. And no doubt the early years of her life have had a great impact on direction her life has taken and the kind of issues that she has chosen to tackle with such ferocity. So let me just give you a quick background. She was born in Brooklyn in 1933. That makes her 86 years old. Her mother, who was a very important figure to her, died when she was in high school, just before she graduated high school. And she graduated valedictorian from high school, and then went off to college. Her mother, I think, was instrumental in Ginsburg's conception of what it means to be a woman in society. Her mother always encouraged her to dress properly and act like a lady, but not limit herself to the social norms that were prevalent even at that time of what was expected of women in terms of career or in terms of ambition or in terms of household jobs and duties. So she went to college. She went to Cornell. That's where she met her future husband, Martin Ginsburg, known as Marty. She married him and while she was at Cornell, and then she graduated valedictorian from Cornell. And the couple then moved to Oklahoma. Marty was drafted, and they moved to Oklahoma to be near Fort Sill, where he was stationed. They spent 2 years there. They had a daughter, and Martin learned at that time that Ginsburg was a terrible cook. She was in fact banned from the kitchen, and so Marty learned how to cook, took quite a passion for it, and ended up being the family chef for the rest of their lives, and ended up being a darn good one too. Published a cookbook, no less.
Wow! And let me just pause there for a second.
Fine.
Let me pause there for a second because that's fascinating and matches up with actually one of the themes that runs throughout her equal protection and gender discrimination cases, which is that we have these stereotypes about gender roles, and of course it was hundreds of years in the making, these gender roles, that men were the breadwinners and women were in charge of the home and all that went with that, child rearing, cooking, being in the kitchen, and all of those stereotypes she really challenged in the opinions that she takes on, the cases that she took on, and the arguments that she make, and that one in particular. And there was one case that I was reading about where a man wanted to be a stay-at-home dad, and she felt, didn't she, not only that the issue of gender equality was about expanding the rights of women to give full meaning to the ideal of equal protection, but also to give men the opportunity to have their roles expanded. Why not a man who is the one to stay at home with the children? Why not a man who can receive workers' compensation benefits when his working wife is injured or loses her life and can no longer, it's not just about women, it's really about women and men and the roles that she challenged throughout her career. So it's fascinating that even in her personal life, it was her husband, Marty, who was the cook.
Yeah, that's a really important point, and it's a theme that you've connected, rightly so, all throughout her life and career. Marty was of the same mind as she was, that it was the gender stereotypes, those role typing norms that were the real culprit. It wasn't her brand of feminism was not Captain McKinnon brand of feminism. Men were the problem. It was that stereotypes were the problem, including stereotypes for men. And Marty was complicit in the effort of dismantling those kinds of stereotypes. He was quite happy to take over the role of homemaker for certain aspects of it. In fact, they shared the child rearing 50-50. They shared the home duties 50-50. And he always said that one of his maybe the most important thing he has ever done was enable Ruth Bader Ginsburg to do what she was able to do. And so they had an incredibly supportive and loving and gender role non-conforming relationship, especially for the time in which they were married.
So, and then she goes on to pursue a career in academia. It's also interesting that she meets with gender discrimination in her own life. There's a great, it's not a great good story. It's a great disturbing story about her time at Harvard Law School. Both she and her husband went to Harvard Law School. And as she comes in as an entering first year, as one of only 7 women, I believe it was, in her class at Harvard Law School, women had only been allowed into Harvard Law School just a few years before that, but there's an initial kind of reception with the dean of the law school, Erwin Griswold, who says to her and the other 6 women in her class, tell me why you think it's okay that you're here taking the place of a man who would otherwise have your place in this law school class. And I think that's
shocking.
Right. I mean, by today's sensibilities, that's shocking. But this was some years ago, and that kind of attitude was quite common, and she experienced it firsthand.
She did, and it was incredibly offensive to her, and apparently to most of the other women there. There were fewer than 10 women matriculated that year, as you mentioned, out of a class of more than 500 students. And they had to go around the room. It was like a parlor game where they had to go around the room and explain themselves as to why they were here, why they were taking the place of a male student. Griswold tried to pass it off as a joke, but it was incredibly uncomfortable and offensive to the people there. It was a tea, no less. It wasn't even over beer or something like that. It was over tea, and just to emphasize the gender role that was being put at issue. And she said something that was relatively benign in answer, but she never forgot that, and it certainly colored her perspective of Harvard. And she did also understand that the gender stereotypes were products of the time, and she understood them as that. But she never forgot them and thought that they were worthy of being changed at the appropriate moment in time. And that's one of the things that she obviously devoted her career to doing.
Mm. And then she did quite well at Harvard, but her husband ends up getting a job in New York City at a prestigious law firm, something that most women law graduates were unable to do in those days, that is, get a job at an actual law firm. But she follows him to New York for her 3rd year of law school at Columbia, my alma mater. And tell us about that, because I think that's also, and the story of how Harvard later tried to offer her a degree, because that I think that's another kind of early experience that she has in the law, experiencing directly those gender stereotypes and the discrimination that was attached to those stereotypes.
Yeah, Marty was diagnosed with testicular cancer while they were in law school, and they weren't sure about his prognosis. But they beat it. He beat it. He graduated from Harvard Law School a year before she did and got a job with White Shoe Law Firm in New York City. And she wanted to move there to be with him, so that they kept the family together. They had a daughter. His health was still in question. And she didn't want to be in Boston while he was in New York. So she asked to transfer to Columbia, but graduate from Harvard. And she applied for that permission to do so, which was routinely granted to male students in these kinds of circumstances. And Griswold again denied her application, saying she had not made out a case for exigent circumstances. So she withdrew from Harvard and enrolled in Columbia and graduated from Columbia with a Columbia degree. She graduated valedictorian, by the way, from Columbia.
Of course.
And of course. And later, in the 70s, different Harvard deans, after she had made a name for herself, Harvard approached her and offered her an honorary degree from Harvard Law School, but it was conditioned on the renunciation of her Columbia law degree. And she very curtly said that she had only one earned degree. It was from Columbia. She treasured it and would have no other. And so she rejected that offer and has always embraced the opportunity that Columbia offered.
Right. And she became, am I right that she became the first tenured law professor at Columbia, ultimately?
She became she started her academic career at Rutgers, but she then lateraled over to the Columbia faculty, and when she did, she was the first tenured woman law professor at Columbia.
And again, that's not only no small achievement, because there were very few tenured female law professors anywhere in the country, really, at that time. Also, by the sort of footnote, her daughter grows up to become a law professor and actually became a very well-known professor at Columbia Law School herself. But also because as she became more committed to advocacy beyond her teaching, and really moved away from, as we were saying earlier, a focus on procedure as the procedural aspects of law, and more to issues of taking on gender stereotypes through cases challenging gender discrimination. One of the cases that she recognizes stands as sort of one of the pillars of the old world of thinking about gender roles was a case that denied women, particularly actually married women, the right to practice law. An 1872 Supreme Court case called Bradwell. So her own achievement to perform so well in college and in law school, and then to become a tenured law professor, one of the top law schools in the country, as she's starting to think about the ways in which she can influence the law to open opportunities for women more broadly. I mean, it just seems like that's a particularly important detail of her own personal story.
Yeah, she absolutely did. I'm sure it was no coincidence or not a lark that she decided to enter the law. I think she saw entering the law as part of breaking through those glass ceilings that had kept women from fulfilling their roles as full members of a civic society. And she did so with excellence and poise all the way through.
Now, part of her, I think probably one of the things she particularly appreciated about being at Columbia is that she was afforded the opportunity to devote a substantial amount of her time working with the ACLU and what was called the Women's Rights Project, which she started for the ACLU. And there's a great chapter early on in the book that looks at one of the very first cases that she becomes involved with, that goes all the way to the Supreme Court. She didn't argue the case, but she was very influential in developing the arguments used in the presentation to the Supreme Court, writing the brief of the case. This was the Reed case. And I had two things that I thought it would be really good to focus on. And we're never going to cover all of the wonderful things that there are to talk about in Justice Ginsburg's career. But I think this is particularly important, and maybe we can address each of these two aspects of her work on this first case, on the Reed case. One is kind of what the legal landscape looked like in terms of women's rights, or really the denial of women's equal rights in the law, as the law defined it and proclaimed it, as she steps into this case and really begins this very important part of her career. And then, I think it's also good to say a few words about the Reed case, because it does set the themes that she's going to develop and press with increasing success throughout the 1970s. So, I mean,
sure.
Do you want to say a few words about? We've talked generally about gender roles, but I don't think people probably appreciate, unless you're old enough to remember back that far, that women really were in so many, many aspects of life, personal life, business life, academic life, family life, treated as, second-class citizens in so many ways. Can you tell us a little bit about that?
Yeah, and this is a phenomenal chapter written by Linda Kerber, who's not a law professor, but a history professor, and has done quite a bit of work in this area. So I really appreciated her contribution to the book, which definitely takes a much more of a historical angle. In the 60s and 70s, the laws revolving around women's roles were pervasive. It was almost a Jim Crow-ish kind of a regime, although they were ostensibly benign. They were designed to protect women, to be paternalistic about it, to protect them from the burdens of litigating cases. Their fragility of women was something the law effectively encapsulated and furthered. It was women should not be troubled with the burdens of sitting on juries, for example, and they should be concerned with the things that are more of their nature, which is child rearing and which is marriage and which is homemaking. And Ginsburg did not dissuade women from taking that path if they wanted to, but she bristled at the idea that all women were the same, that women would naturally choose this path, and that they should be encouraged to choose this path and dissuaded from making choices outside of that arranged path. And so she got involved in this case called Reed versus Reed. It was a challenge to an old Ohio law that gave a preference to men to be administrators of a will. And in this case, Sally Reed was the logical person to be the administrator of her family's will. And but the law nevertheless gave the court the authority to appoint someone else, and in fact instructed the court to preference some male administrator. So she challenged this case, and she wrote a brief for it, helped write a brief for it, a very detailed brief for it. And the brief arguments were a fundamental attack on the role that the law played in entrenching gender stereotypes. She acknowledged this was sort of a benign law. It was designed to protect women from the burdens of being an administrator of a will. But to her, that was equally offensive, especially for someone who wanted to be involved in that process and was the right person to be involved in that process, just happened to be a woman. It was not anything about that women couldn't be administrators to the same degree as men in terms of quality. It was rather an entrenchment of stereotypes, and her brief really attacked that role and convinced the court.
Well, the law in
equal protection clause.
The law in question actually provided that as a first matter, when the court needed to look to see who should be an administrator of an estate or of a will, that it could be a husband or wife, but the law actually explicitly says that males must be preferred, and the chapter really explains that, as you've pointed out, that much of the attitudes that formed these laws that gave men preference and that kept women from many activities and even civic responsibilities. And this is now many decades after women received the right to vote finally in 1920. We're talking about the 1960s and early 1970s. But also beyond protecting women, it was these attitudes derived from centuries of tradition of social values and of many ways in which the law followed or even reinforced those social values, that the man, particularly in a marriage, the man essentially owned the woman. The woman was his property. She was under his control. Even her body was her control, which of course becomes very important not too many years later when the court takes up abortion. So she was really taking on, not just some odd statute, on some obscure issue like who should be in charge of administering a will. She's really taking on, in this case, the whole enchilada, so to speak, centuries of social and legal tradition about what gender roles are and should be.
And that's correct. The Supreme Court did not endorse all of those arguments, of course. It did rule in her favor. Sally Reed did win, and the court invalidated the Ohio law that preferenced men because it was not a classification that was justified under the Equal Protection Clause. And it was one of the first cases to extend Equal Protection Clause to protect to prohibit gender discrimination. But it did not offer Ginsburg the sweeping reforms that she was hoping to make or justify the broader and more fundamental attacks that she was making in her brief on gender roles. But it was indeed a path-marking decision for both women's rights and for Ginsburg's agenda overall. She relied on that in future arguments to the court and won a number of other additional cases that continue to build on the gains made in Reed. And when she became a member of the court, she, of course, built on those wins in deciding cases for the court that continue to advance gender equality.
I'm wondering what you think about this, because if we think back to this time, the 1970s, of course, this was a time of great change, of social change in our country. We had come through the civil rights movement. The Supreme Court had made landmark rulings like Brown versus Board of Education on racial discrimination. Congress had addressed, at least in law, aspects of racial discrimination, ending racial discrimination in voting and housing, and invalidating other state laws that look to protect separation of people based on race. And there's a rising consciousness, too, among women at this time. The Equal Rights Amendment, begins to gain attention and actually passes the House of Representatives right around this time. Roe versus Wade is decided in 1973. So it's a time of great change in and outside of the law. I'm wondering, as she continued her work through the 70s, and finally is appointed to the Supreme Court as only the second female justice to the Supreme Court, the first being Justice O'Connor. President Clinton, who appointed her, referred to her as the Thurgood Marshall of women's rights. So how important do you think was her work, both as an advocate and then when she gets on the Court of Appeals and then when she finally is elevated to the Supreme Court? How important do you think the court decisions are in advancing this cause of equality and non-discrimination based on gender versus some of the other ways in which the march for toward equality on the basis of gender was happening outside of the law? That's I know that's a huge question, but
well, the women's rights movement was broad and had many leaders, and could not have achieved the success that it did without many of them, all coming together, not necessarily in a completely coordinated effort, but each making some strides in their places. And Ginsburg was a player. She wasn't. I don't know if she would ever endorse the analogy to Thurgood Marshall. It's been made before by Bill Clinton and Justice Scalia and others. I think she would justifiably remain modest about her role. It was an important one, especially on the legal side of things. She had a lot of firsts. She was a representative character of the movement, at least the movement as it pertained to the development of the law in the courts. And she had great success. She definitely was a player in that movement. But it was also a very broad movement with many leaders, many important leaders. Her cases have the benefit, the cases that she won as an advocate and the opinions that she wrote as a judge, they do have the great benefit of being a continuing legacy. They are precedent. They are what the law relies upon, and they are the building blocks that are difficult to remove from the law now as precedent. And when she cites to those cases, when the court must cite those cases, even in cases like the gay marriage cases that were in some ways built upon the foundation that Ginsburg developed back in the 1970s. That is a continuing and enduring part of her legacy.
One of the, it's often described as perhaps one of the most important opinions she wrote on the Supreme Court is the case involving the Virginia Military Academy, which had long been a single-sex school and barred women. Can you talk a little bit about that case and why that stands as one of the important foundations of her Supreme Court legacy?
Yeah, VMI, as it's known, it's probably her most famous case. It was written in 1996. It was a 7-1 opinion that basically held that the Virginia Military Institute's admission policy of admitting only men was unconstitutional under the Equal Protection Clause. And it's in all the con law case books because it's the first case to articulate a heightened scrutiny standard for gender classification under the Equal Protection Clause. The facts are pretty simple. VMI was an all-male institution. A woman was qualified, except for her gender, and wanted to attend, but she was rejected based on her gender. Virginia had erected an all-female counterpart that was grossly inferior and did not obviously have the same kind of cachet that VMI did. And the case went to the Supreme Court, and the Supreme Court said that kind of gender classification for this kind of educational opportunity was unconstitutional. It may very well be, Ginsburg said, that some women do not want to attend a place like VMI, but the law can't prohibit them from doing so if they wish.
Right. So it gets at this whole issue of stereotype. I mean, it may even be that most women wouldn't want to go to VMI, but the fact that some would means that you can't build the law around those stereotypes. I mean, I think seems like such a core value that runs throughout most of her work in this area.
Yeah, her style of feminism is choice and opportunity based. The law can't tell women what to do. It needs to offer them the choice. And even if most of them would choose the particular gender roles that are common for the time, the law shouldn't prohibit other women who wish to go outside of those roles from doing so and from realizing their full potential.
So you mentioned that it's the first time this VMI case and this very scholarly opinion that she writes in the case, where she really traces not just the facts of this particular case and why it should be decided in the way it was decided, but she really uses the opportunity in this opinion to give a full dissertation on the law in this area. You mentioned that it's the first time that a heightened level of scrutiny is endorsed by the court when it comes to cases involving a question of gender discrimination. For the non-lawyers listening, what does that mean, and why is that so important?
Well, the equal protection challenges are normally based on what's called rational basis scrutiny, which basically will uphold a law if there is any rational reason for it, even if it didn't happen to be the particular reason the legislators had in mind when they passed the law. But certain other kinds of classifications, especially those based on race, have long been held to a higher burden. It's not just any rational classification. It's a strict scrutiny. There has to be a compelling governmental reason, and that is narrowly tailored to its objective. In race, that's almost never satisfied today. And race-based classifications, with the exception of, say, affirmative action cases. Race-based classifications are widely held unconstitutional in the Equal Protection Clause. And there's a long history for why that should be the case, and why society should endorse that kind of standard. The gender classifications were sort of in between for many years. And in Reed versus Reed, the case that Ginsburg participated in 1971, the court did endorse the idea that the Equal Protection Clause could invalidate gender classifications, but it didn't set the particular standard for which the Equal Protection Clause would do so in gender cases. In VMI, the court finally set that standard and set it at an intermediate level of scrutiny. So it wasn't quite as strict as race, but it was certainly much more demanding than the ordinary rational basis level of scrutiny for other equal protection challenges, for the ordinary kind of equal protection challenge. So it did elevate gender classifications to a special and more scrutinized level that set them apart from the ordinary equal protection challenge.
And that becomes important because that benchmark standard is then available to challenge other laws, other state laws that do discriminate or treat differently women from men for reasons that can't meet that high burden of showing an important government purpose in setting that different classification, right? That is an incredibly influential standard once it's applied to so many different situations over the years that followed.
Yeah, that's exactly right. And now gender-based, sex-based classifications are quite suspect under the law. They are, I wouldn't say presumptively invalid, but everyone knows that they must meet a more rigorous standard to be considered valid. There are some obvious social circumstances in which sex-based classifications make sense, privacy in locker rooms and things like that. But for the most part, in ordinary social roles in society, gender classifications are highly suspect, and VMI is the single most important foundational building block for the gender classification law as it's developed since then.
Well, this is going to sound like a strange intro to my next question, but there's really sort of two personal experiences I've had that lead me to this question. First of all, when I had the privilege of being admitted to the Supreme Court, to the bar of the Supreme Court, you go to the Supreme Court, and there's a little ceremony, and all the justices take the bench, and then you're sort of sworn in, which allows you to practice in front of the Supreme Court. And on the day I was there, it was, of course, it's a great honor for any lawyer, and it was It was especially nice because Justice Scalia was still alive and was on the bench that day. And, of course, Justice Ginsburg was there. And you can barely see her when you're sitting in the court. She's so tiny. Her head barely makes it above the bench as she sits behind in her seat. And then more recently, I was in Helena, Montana, of all places, where I have a case, and I was in a gift shop there. And, it's one of those gift shops where they have bumper stickers and keychains and little buttons and things like that. And in Helena, Montana, there was a whole array of Ruth Bader Ginsburg gift items, buttons that just say RBG, bumper stickers with her face that says, I dissent. She even has a rap nickname, Notorious R.B.G. So I'm putting these together because, here's this remarkable person of, truly outstanding achievement in the law. And also, by the way, somebody, and this is discussed in several places in the book that you edited, who, though she was frequently at polar opposite ends in cases from one of the other sort of personality cult-like Supreme Court justices, Antonin Scalia, outside of the courtroom, they were really good friends and loved each other's company. If you put all of those observations together, how would you, what does that tell us about her legacy once we leave aside the subject of the specific cases that she worked on and the specific successes that she had as an advocate and later as a judge and a justice? Putting some of those observations about her as a person, what does that say, do you think, about the legacy of Justice Ginsburg?
Yet her personal experiences on the court, I think, are both formative for her and also are reflective of who she is as a person. She's very thick-skinned. She can debate those of a different ideological bent with the best of them, but she doesn't take it personally. She enjoys good company. Some of her favorite people on the court, I think, were those that she regularly disagreed with in opinions. Justice Scalia, the late Justice Scalia, the late Justice O'Connor, whom she had a special affinity for as the only two women on the court.
Justice Rehnquist
and Chief Justice Rehnquist, who she called my chief, and was very, very fond of.
Yeah.
And those personal relationships and the way that she dealt with people, I think, were emblematic of how she hoped, what she hoped for the world. That it was reasoned and spirited debate, but ultimately an understanding of community, that we are all members of the same community. That we're all hoping for better things. She spent New Year's Eve with Justice Scalia and his family many times. She went to the opera with them. They shared a love of opera. She actually, there's some indication that she actually helped persuade Chief Justice Rehnquist on a couple of very key cases, including one called Nevada versus Hidd, which was a gender discrimination case in which he fairly inexplicably joined the liberal justices in voting to strike down a provision of the Family Medical Leave Act based on the Equal Protection Clause and gender discrimination. And he wrote the opinion, and it even though he wrote it, it's read exactly like something Ginsburg would have written. So some of those personal relationships, no doubt, have influenced the development of the law, even when she wasn't actually writing it. And you see that too in some of the dissents that she's written, which has really generated some of her outsized media persona too. She's written a number of dissents, very vigorous dissents, that she's continued to advocate for those dissents, even after the case is over, some of which have resulted in post-case wins. One very famous one was a case involving a woman at, I think it was Goodyear, who was paid less than her male counterparts. She sued under Title IX for sex discrimination in pay. And the court ruled against her because of a technicality in the statute, not that she wasn't discriminated against, but rather that she didn't bring her claims in a timely fashion. And Ginsburg wrote a dissent about why she thought the majority had interpreted the law incorrectly on that point. And Congress agreed with her and overturned the court's decision by amending the law. It was called the Lilly-Ledbetter Fair Pay Act. Ledbetter was the plaintiff in the case. And so her dissent, even though it wasn't controlling at the time, really led the way in changing the law and making the world a better place for the Ledbetters of the world. And I think that's really contributed to her, popular fame. The Notorious R.B.G. and she's, an iconic hero for millions for basically her quiet forcefulness. As Dahlia Lithwick writes in her chapter, she's more ninja librarian than raging gender warrior.
Yeah.
And so she's got this iconic status that she hasn't dissuaded cultivation from. I mean, she in person she's very soft spoken. She's very deliberate. She's incredibly courteous. And so she's not a bombastic kind of argumentative person in face-to-face interaction. And yet she's become the symbol of vigorous yet quiet dissent that has resonated with a large segment of the population.
Well, and we live in I made a comment about this at the outset, that when she gets a cold, millions of people hold their breath, and I think it's a very shallow point that I made, but though it's true, because it unfortunately reflects, I think, the so severely partisan times that we live in, where we don't really know Supreme Court justices the way we know some of the more outspoken members of Congress, or of course the way we know our presidents. And what we do know, if we know anything, is we know how to count. And I think a lot of people do hold their breath, and she has had bouts of poor health. She's survived cancer twice herself, and was recently hospitalized just a week or so ago, briefly, because the court is seen as so vital. It is so vital, and every vote counts. And will a conservative or a liberal control the seat that she currently occupies when, as will necessarily happen at some point, she leaves the court. But to look at her as more than just one of the liberal Supreme Court justices, but to see her career in its much fuller sense and appreciation, I think is really worth consideration. It's really worth all of our time to understand all that she's done and all that she's meant to the law and to women and men in the country. So I think the book is really terrific for anybody who wants to learn more about that. Are you? I may have this wrong, but are you working on or planning some kind of update to the book that we could look forward to in the future?
Yeah, so the book came out in 2015, so there have been some additional cases and additional developments in the last couple of years, and I'm in preliminary conversations with the publisher to put out a second edition maybe in the next couple of years that would have some modest updating. But, in a 60-year career with the law, the last 5 years while they may have some importance to them, is really more of an updating kind of effort. So there'll be some changes here and there, but I think the book, even as it currently stands, is fairly reflective of her and her legacy.
Well, and again, it's called The Legacy of Ruth Bader Ginsburg. It's a collection of short and very readable essays looking at her time as an academic, looking at her time as an advocate and an activist in this area, looking at her time on the court, of course, going through some of the important cases that have been so influential, really covering her career fully, and it's terrific. And the book, of course, is edited by my guest, Scott Dodson. So, Scott, thank you very, very much for being on the program and helping me learn more about Justice Ginsburg and helping our listeners learn more and appreciate more about her legacy. Thanks so much.
It was my pleasure, Aaron. Thank you for having me.